Washington Justice Anthony M. Kennedy, who almost certainly holds the crucial vote in the case of a Colorado baker who refused to make a wedding cake for a gay couple, sent sharply contradictory messages when it was argued Tuesday at the Supreme Court. He asked a lawyer for the Trump administration whether the baker, Jack Phillips, could put a sign in his window saying, "We don't bake cakes for gay weddings." The lawyer, Noel J. Francisco, said yes, so long as the cakes were custom-made. Justice Kennedy looked troubled and said the administration's position was an affront to the dignity of gay couples. Later, though, Justice Kennedy said that a state civil rights commission that had ruled against the baker had neither been tolerant nor respectful of Mr. Phillips's religious beliefs. The case, which pits claims of religious freedom against the fight for gay rights, has attracted extraordinary public attention and about 100 friend of the court briefs. Mr. Phillips says that he should not be forced to use his talents to convey a message of support for same-sex marriage. The couple, Charlie Craig and David Mullins, say that businesses open to the public should not be allowed to discriminate against gay men and lesbians. Tuesday's argument, which lasted almost 90 minutes instead of the usual hour, appeared to divide the justices along the usual lines. The more liberal justices probed whether all sorts of artisans, tailors, hairstylists, makeup artists, chefs could refuse to supply goods and services for same-sex weddings. Conservative justices considered whether artists can be required to convey messages with which they profoundly disagree. Kristen K. Wagoner, a lawyer for Mr. Phillips, said her client was an artist, one who created a sort of sculpture. Justice Sonia Sotomayor appeared unpersuaded. "When have we ever given protection to a food?" she asked. Justice Stephen G. Breyer said the questions served a purpose. "Where is the line?" he asked. "That is what everyone is trying to get at." Both Ms. Wagoner and Mr. Francisco said that it would be harder to justify discrimination against interracial couples than gay ones. "Race is particularly unique," Mr. Francisco said. That distinction did not seem to sit well with some justices. And David D. Cole, a lawyer for the couple, said it would relegate gay and lesbian couples to second-class citizenship. But Chief Justice John G. Roberts Jr. said the court's 2015 decision establishing a constitutional right to same-sex marriage had anticipated good faith disagreements over gay unions. The court went out of its way to talk about the decent and honorable people who have opposing views, Chief Justice Roberts said, referring to Justice Kennedy's majority opinion. The Chief Justice had dissented. The remark was a sign of Justice Kennedy's central role in the case. Masterpiece Kakashop v. Colorado Civil Rights Commission, No. 16-111. He is at once the court's most prominent defender of gay rights and its most committed supporter of free speech. In his majority opinion in the 2015 decision, Obergefell v.